Let's shift focus onto this. Some legal practitioners have criticized Parliament's proposed bill to establish land reform courts. It is hoped that the courts will speed up resolutions to land disputes. The Land Court Bill now awaits President Cyril Ramaphosa's signature. We are now joined by Bulelwa Mabasa, a lawyer and land reform expert, on how far this intervention will go. Thank you so much, ma'am, for your time this afternoon.
It's lovely to be here. Thank you.
I think I'd like for us to begin with the preamble in terms of a historical context that the South African gives on the website in terms of the land issue in South Africa. If we can also bring that up for our viewers to take a look. And it reads: the dispossession of land through the 1913 Natives Land Act was apartheid's original sin. The land question goes back more than a century to the 1913 Natives Land Act, which provided legislative form to a process of dispossession that had been underway since colonial times. In 1913, Natives Land Act saw thousands of black families forcibly removed from their land by the apartheid government. The act became law on the 19th of June in 1913, limiting African land ownership to 7% and later 13% through the 1936 Native Trust and Land Act of South Africa, and so it goes. And given that in 1998 there were thousands of land claims that were submitted by various South Africans, what would you say the progress has been in the country?
The progress has been woefully slow. As a legal practitioner and as an attorney who has specialized in land reform cases, I have cases that I'm dealing with currently where communities, families in all walks of life in various provinces submitted land claims in 1998. We're still sitting today with many of those claims that remain unresolved for a myriad of reasons, many of which being that a lot of these communities do not have access to good legal representation. They do not have access to legal representation that is specialized enough to understand the land reform context. But also communities have been marred by internal disputes, because if you can imagine, thousands of communities are expected to have the same views around what they want to do with the land. But I think chief amongst those reasons has also been the resourcing of the Land Claims Commission, which is a commission that is tasked to research and investigate those claims. Often we find that the investigations are slow. There is a lack of capacity to research these claims. And in fact, one of my favorite books that I've read recently by Lucas Lutwaba lament generations of people that submitted claims who are now deceased. Yeah. Because if you can imagine, in order for for a restitution claim to be proceeded with, it needs people that can attest to the dispossession and so forth. And, of course, the fact that we've had a land claims court all along that has not been properly resourced. We don't have permanent judges in the land claims court. A lot of the communities don't have, as I said, sufficient legal representation or even access to justice. The land claims court revolves around the city, although its main seat is in Randburg, with many of these communities living in the rural areas in Mpumalanga, Limpopo, and etc.
Yeah, it does sound like this pudding has a lot of elements that will not allow it to be all that tasty. When you speak of good legal representation, what has been the resistance in affording people good legal representation?
So the state has a program that allows communities to access legal aid. But the rates that the state affords lawyers that are specialized in land reform areas are so low that it becomes a disincentive for specialized lawyers to assist in these cases. But also, the restitution framework is highly specialized with few legal representatives in the form of attorneys or advocates that have taken the interest to build expertise around this area. So what you then find is that you end up with communities being given lawyers who don't have experience in the area, and lawyers who aren't able to progress the matters because they don't have the experience or the expertise. So what the latest intervention was that the legal representation for communities has been moved to the Legal Aid Board, And the Legal Aid Board, as you know, is not focused on dealing with complex cases, and a lot of these cases do have a lot of nuances and complexities. So it also is linked with the fact that the Land Reform Department itself does not enjoy the lion's share of the budget. So if you can imagine, the lion's share of the budget goes towards healthcare and education, leaving the Land Reform Department with almost less than 1% of the fiscal budget. And because of that, a lot of the issues flow from the lack of resourcing in proceeding and successes and finding successes in land reform cases.
And that begs the question, how far will the changes to this bill, the Land Claim Courts Bill, then go?
So it's an important step to have a court that is well-resourced, that has permanent judges, that has a land court, appeal court as well. However, that is not, as you correctly pointed out in your intro, that is not going to be the magic bullet. What we also need is a redistribution bill which will allow people who need land to also be able to access land, because currently the statute that we're all relying on, which is the restitution statute, is where people must prove claim to land. So the dispossessed must prove that they were dispossessed, it was after 1914. So the burden of proof is very high with restitution cases. We still have thousands of cases that were lodged in 1998 that have still not been resolved. And in fact, what happened in 2014 was that there was an attempt to extend the deadline for land claims, which also saw 3 times more land claims being lodged than the 1998 deadline. And so the absence of legislation that deals with giving people access to land without having to prove a claim to land rather, is what is critical. And also what we've seen is that with a lot of the land reform cases that deal with evictions and so forth, you have a lot of people that don't have legal representation, that don't have access to courts. And also the commission itself suffers from a depth of skills and resources such as historians that are able to research all these claims. So the land court bill will go some way, but the issues with land reform are much wider than just having a land court bill, a land court.
Is it all rhetoric? Because you will hear from the highest echelons of leadership, whichever, well, maybe we can name but 2 or 3 parties, that will talk about the issue of redress, that will talk about the issue of land in South Africa. For instance, you've also got Vision 2030 and the National Development Plan that also speaks about enabling more rapid transfer of agricultural land to black beneficiaries without distorting land markets or business confidence in the agribusiness sector, ensuring sustainable production on transferred land, establishing monitoring institutions to protect land markets from opportunism, corruption and speculation, and so it goes. I mean, 2030 is around the corner. Are we still going to be speaking about this issue for the next 30 years?
If you think about it, the 1913 Land Act, which was the legislation that dispossessed people of land, is now 100 years old. It turned 100 years old last week. And so it's quite disheartening that we're still talking about the issue of land. As a member of the Presidential Advisory Land Reform Panel, we made significant recommendations that are yet to be made into law. One which is, as I mentioned, the Redistribution Act will allow more people to have access to land without them having to prove it. We've also recommended a land donations bill, which I'm not sure when it's going to be enacted or even put forward to Parliament, because that will allow and widen the private sector, the role of business into making land available to those who are in need, and to donate land without it having to be a forced process. So the reality is that whilst government has the national competence to resolve the land issue, it's going to need a concerted nation-building effort. And in fact, the most important part of that is enabling those that do get the land to have post-settlement support in the form of strategic partnership with business to ensure that once land is received, there's sustainability, there's productivity, and so forth.
Very quickly for us, you also spoke of internal disputes in terms of communities. How do we address that, and how do you assist in terms of taking the process forward?
So the internal disputes between communities vary. most of whom deal with the fact that most of these communities are sitting on communal land. Now, we don't have legislation or a proper system that enables communities to hold land in a structure that is legally recognizable. So we find that even with investors that are trying to invest on land that is communally owned, because that land hasn't been surveyed, you find that it's difficult for legal instruments to be set up in order for those communities then to be able to proceed with investments. So it's going to be a very important issue to enable communal land to be held in legally recognizable structures. And so far, community trusts and community property associations have just been a storm in the fact that communities aren't able to come to a resolution in how the land must be used.
It can't just be another slogan. Thank you very much for your time this afternoon. Bulelwa Mabasa is a lawyer and land reform expert.